Good morning, everyone, and for those of us joining us on from a different timeline, good afternoon and welcome to this morning's event. It's a great pleasure to be here. My name is Priya Shetty. I am the Regional Director at EndCode, and we are one of the hosts of this morning's meeting, where we will be launching the model guidelines on age-appropriate design for online services. Let me also take the opportunity to welcome our co-host, our esteemed co-hosts, the Center for Human Rights from the University of Pretoria. We're very proud to be co-hosting this event with you, the culmination of months of work on what has really been a project of passion for us. So thank you again to the Center for Human Rights. A big warm welcome to all of you joining us, just having a look at some of the participants, from regulators, from industry experts, to online service providers, to techies, developers. So many of you in the room, thank you all for being here this morning. It isn't a very long session, but we'd love to talk to you about where we got to with this specific project. If you haven't heard of this before, this is the third of our event series, but if you haven't heard of this before, these model guidelines are developed for online service providers who would be interpreting privacy regulation at the design stage of their products and services. And so it is a principal set of recommendations that we have put forward just on considerations on how to meet some of the requirements under these privacy regulations from a principal perspective. And we'll hear more about that from Alon from EndCode just a little later on. So as part of just some introductions, just a little bit of context. Why would we develop these model guidelines? They emanate from some funding that we receive from the Africa Online Safety Fund, which is a fund that is managed on behalf of Google.org, which is the philanthropic arm of Google. And we saw something missing in the regulatory landscape that translated some of these developing and emerging principles around children's privacy online and children's rights, and the way in which online service providers and product developers could actually interpret these rights and these principles into the way that they work. So, it took some brainstorming to get to the concept of the model guidelines, and then develop the research that presents it in the current form. It starts out with a very kind of fundamental principle about the recognition for the best interests of the child. And internationally, this has grown to become a very well accepted children's rights principle, as fundamental as it is. To always just be looking out for the best interests of the child. In Africa, in the African Charter on Rights and Welfare of the Child, there's a requirement that in all actions concerning the child, that we should be looking out for the best interests of the child, and this should be a primary consideration. Even in the African Declaration of Principles on Freedom of Expression, there is that requirement to recognize and respect the evolving capacities of children. Another fundamental principle that suggests that we shouldn't apply the definition of children in a kind of overly universal way, but really take into account that we would have a range of evolving capacities of children at different ages. And this is where the principle of age-appropriate design comes in. In South Africa, even at the constitutional level, we have this mandate for the recognition for the best interests of child, always taking into account a child's well-being. The Children's Act, which is really that universal law that applies to all aspects of protection of children, also recognizes the best interests of the child as being of paramount importance. And while POPIA does not, our own privacy law, the Protection of Personal Information Act in South Africa, does not explicitly mandate respect for the best interests of the child and recognition for that evolving capacities of children at different ages. There is a fundamental principle of accountability within POPIA, and this is where our work is derived and how we make that link to privacy regulations. We suggest that these recommendations for online service providers can go quite far in helping these product developers and service providers meet POPIA's regulated standards in how they engage with children. So, pulling it together, why develop model guidelines? When an online service or product is likely to be accessed or used by a child, online service providers must consider the best interests of the child to ensure that their privacy practices and communications are suitable for children at their evolving ages and capacities, and ultimately in their best interests. And that's been the kind of rider for this project, really informing everything that we have done. How we got here, we consulted a range of frameworks on children's privacy and human rights, the Declaration of Human Rights, the Convention on the Rights of the Child, the African Charters on Rights and Welfare of the Child and Human and People's Rights, the African Union Convention on Cybercrime and Cybersecurity, and then a range of models, guidelines, best practices, and other policy and regulatory tools on age-appropriate design, an emerging area suggesting how we might approach this topic. Very informative design code from the UK, the UNICEF toolkit, the UNICEF guidelines for industry on children's online protection, and various other guidelines. We developed a vast research report that is available on the dedicated website for this project, which we will share in the course of the presentation. This resulted in draft recommendations. We then had a series of consultations with various groups, including parents, and this culminated in how we developed and consolidated the model guidelines. The agenda for this morning, just those introductions from me, and then a presentation by Dr. Elvis Porcala on children's privacy online. Then a presentation of the model guidelines themselves by Alon Alkale from EndCode, a visual presentation by T. Manure from Obsidian Circus. We're very excited to have engaged a visual artist for this project to interpret the model guidelines in a visual way, and she will present that a little later on. Just some Q&A before we close the session. So with that, it gives me great pleasure now to introduce our first speaker, Dr. Elvis Porcala, PhD. He's the manager of the Children's Rights Unit at the Center for Human Rights at the University of Pretoria. Previously, he was a postdoctoral fellow at the University of Stellenbosch and a teacher at the Institute for Human Rights. He writes and publishes predominantly on children's rights in Africa. His research interests include international children's rights, public international law, African human rights system, and constitutionalism in Africa relating to vulnerable groups. It's a great privilege to have you with us. Let me hand over to you, Dr. Porcala.
Can you hear me? Thank you. Thank you for that introduction. I'm sure that I'm able to share my screen now. Yolanda, can you see that?
Yes, it's visible.
Okay. Yeah, before I start, thank you for that introduction. And just to say, I see that in the group, we have some of our colleagues from Senegal, and to say bonjour à tout le monde qui est basé à Sénégal ou peut-être dans les pays francophones. Juste pour dire que malheureusement, nous n'avons pas la tradition simultanelle, mais que vous pouvez aussi poser vos questions en français. Et nous allons répondre comme nous pouvons, donc disons à la fin de la présentation. and hello to everyone who is from the other English-speaking countries. And Portuguese is still very, very bad. But given that we have all these different languages across the continent, I thought it wise that it's important that we also say hello to those of us who are based in the French-speaking countries. But for us to start, and thank you, Priya, thank you to Ellen, and thank you to EndCode as well for collaborating with us as a center, and so that we are able to introduce what we see from our own, where we sit, and especially from an African perspective, what are the dangers that play out online, and some of the things that are also important for us to take note of. The reason why this presentation looks more on the continent is because there are several authors that have written on issues around privacy and online, the dangers that exist online for children across the world. And but when I went through most of those presentations, there are certain salient issues that are missing and that speak particularly to the continent. And those are those issues that I intend to flag, that we see that do not exist in the amount of literature that I've gone through, and the events that I've attended, and some of the programs and activities that we as a center as well and the Children's Rights Unit have also generated and implemented across the continent. Because of limited time, maybe I just go straight to the issues that we have to discuss. The first point that I want to take us through is for us to understand the fact that today we are in a world where I sit in my own space, just like you, where we are able to communicate with internet, and we can use internet for several other issues that we want to do. You can find basically everything on the internet. And that is why the dangers are so much pronounced in our activities, and especially those who are vulnerable or who do not really understand the intricacies that play out in that environment, that they have this susceptibility of being victims of those dangers. And one of those is children. And that is why we are looking at it from this angle. As you see from the slide that you have in front of you, is that when it was conceptualized, the idea of internet, it was for two groups: the defense force in the US and for the academia. So those of us who interact with literature and research, it was initially meant for us. But today, I promise you that the speed at which the users of the internet, to the space of the internet, has increased. It has involves and included different groups of persons or individuals and people that were not initially in the conceptual framework of the internet. But as we go on and how it has developed into what it is now, and today we have it in our continent, it is important to note the fact that in 2011, when the then UN Special Rapporteur looked at the fact that even though we have the internet, and I look at this particular inception that I've included here as one of the statements that projected the internet as a right, or access to internet as a right. So it has now become something that we use in our home, something that everyone wants to have. There is the aspect of continuous connectivity that everyone has. And this is particularly because the internet also enables us as humans to realize different aspects of our lives, different rights that concerns us. And this is also important to children as well. And I need not dwell much on what 2020 brought to us, and that is COVID-19, and how it made the right to education very much pronounced through access to internet in the continent and of course and beyond. So, but I will not dwell on that because that is common knowledge now. 1 year or 2 years almost into the pandemic in the continent, most of us are used to that. The point that I want to flag on this particular slide is the fact that the then UN Special Rapporteur is saying that it is very, very important that all states facilitate access to internet, and that in doing so, it asserts a positive obligation of the states in making internet widely available, accessible, and affordable to all. So it is therefore no surprise that as we sit at this moment, we now have internet almost everywhere. All of us, everyone is almost always connected. So there's some level of perpetuality in connectivity. We have internet in our pockets, we have internet in our laptops, we have internet everywhere, and it has become the thing that states want to embrace, and especially considering that we are moving towards the fourth industrial revolution at the moment. But the other thing that Priya also brought up in her introductory remarks is the issue of the child's evolving capacities. And this is something we need to take very seriously. And the reason why I say this is because in the subsequent slides that you will see is that as parents, or those of us who have children, is that as parents, we are being overtaken by the younger generation. They are quick in knowing what to do with the gadgets that they have. They are also quick in their interaction with the internet. So in a way, there is something that has happened, and which is something I've described in some of the work that I've done, that it seems like children these days are born with a chip in their system, in their DNA, a technological chip that allows them to interact with the internet at a very fast rate. While we as parents, we take our time to read the manuals that come with a modern television, or that comes with a laptop or an iPad, before we complete reading that manual, I promise you, if you have a 7-year-old, for example, in your space, that child will be able to analyze and able to decode certain things on that iPad before you finish that manual, before you finish reading the manual. But what the evolving capacity of the child is simply telling us in this particular space is that, and I refer to Article 5 of the UNCRC because that is where it is codified in that particular convention, is that there is an evolution of a child's understanding. And this, we don't have to say it much because we all know it, that from an infantry stage, of course, there's the level of understanding when the child gets to adolescent is also different, or to the teenage age is different in many ways, and how they interact. But what I want to insist or flag here is that the argument of the urban and the rural divide of where children grow. We all know that the evolving capacities of a child is in many ways developed and fortified by the environment in which the child grows. So irrespective of what happens within the family setting, but that environment usually guides and fortifies the child's ability to interact with the gadgets that they have with them, or with the challenges that they face in their own world. You might have an argument that maybe those who are in the rural setting are safer, that they will not have a lot of dangers online because they do not have connectivity, or that those who are in the urban areas are more at risk with the dangers. This will also be highlighted in the slides that come up. But the UNCRC then went up to say that meaningful access to digital technologies, that is for children, can support children to realize the full range of their civil, political, cultural, economic, and social rights. However, if the digital inclusion is not achieved, existing inequalities are likely to increase. New ones may arise. And this is why I started by bringing in the urban and the rural divide. If it is not achieved, if connectivity is not strengthened across a particular state, then inequalities that already existed or pre-existed before the advent of internet will increase in many ways, because the child who is in an urban area and has access to all these gadgets, has access to connectivity, gets to learn more, will gain more than the child who is in a rural device. So it's important that state parties take note of that particular paragraph. That's paragraph 4 of the UN Committee on the Rights of the Child, General Comment number 25. But then we move away from this, because at this point, what the UN has done is that it has placed in our minds, it has placed in our own private setting and both in the public setting, the importance of a child to access internet for different reasons. And I would definitely encourage you to read that general comment if you haven't done so. But how far are we as a continent, and what plays out? How do what the access to the internet in the continent, how far have we come? According to the Internet World Statistics, that's 2020 stats that was released. It said 39.3, almost 40% of countries or people in Africa now have access to internet. And I want you to look at that and juxtapose that with the current population of the continent at the moment. And you will see that the advent of internet in 1969, the introduction of the internet in the later part of the 20th century in Africa, and today in 2021, that the access or penetration to internet has increased proportionately across the continent, and it still does so on a daily basis. I spent some time on the Internet World Stats website, and also on the World Odometer, the world population. And the figures keep moving because they have a current recollection of the access to internet and the growing population. Of course, you have to understand that because the issue of birth and the issue of purchase of service providers with internet and technology. But so the number of children online has also grown to a very, very huge rate. And this is because of the population of Africa, which is predominantly youth. The median age is 19.7 years old across the continent. That is from Stellenbosch right up to Alexandria in Egypt. And out of those 19, we know that children are people below the age of 18, which means that a good percentage of the 19-year-olds across the continent are children, which makes it very clear that the risks that children face they are the majority of those who are vulnerable to the dangers that exist in their online interactions. In 2020, that's last year, the Center for Human Rights conducted a study across the continent with all these countries that I've listed here, where we looked at the regulations that exist in all these countries. We look at what plays out in the countries in terms of the regulations and how they regulate children's interactions with the internet. So I got this from that study because I thought it was very important to bring it forth in this conversation, and to also flag the fact that even though all these countries, as was found in that report, they all have internet regulators or laws in place, and they have industry watchdogs in place that supervise access to internet. All of them do not really point to the direction of protecting children online, which means that in a way, we do have a gap. Commercially, yes, it is allowed. They do have these regulations that protect and regulate internet service providers, but they do not have laws that particularly speak to the internet users. And I'm looking particularly at children. So I have a problem with my slide. I don't know if you see that. Are we back online? Priya?
Yes, we're with you, Doctor.
We are.
Yeah, I thought we had a problem there. So I just want to come back to this slide and then to do that. Okay, but as you spend time to interact with the literature that exists here, you will see that we have a certain number of percentage of people who access internet on a daily basis in some of the countries that I've indicated here. We have this data with all these countries that are flagged here, but I thought I should give this or provide these examples that we have here. In some countries like DRC, we have only 17% that have access to internet, but importantly or interestingly, in Burkina Faso, they have 21%, but there is also the issue of gender that plays out there. If you read that more closely, and how girls and women still face some problems with access to internet for different reasons. And the next presentation that we have is that, so if we leave from the genesis of the internet in the continent, the coming of internet in the continent, the evolving capacity of the child, and dangers that plays out there, you would expect that at this point, the Committee on the Rights of the Child might maybe follow into the footsteps of the CRC committee to maybe provide a guideline or whatnot. Notice the committee is silent at the moment, and it is understandable that why the committee is silent, because there is already a general comment, which I indicated earlier, on the aspect of technology, or children's interaction with technology. And for me, I think these guidelines that are being provided now, or that are being discussed today, come in at a time that is very, very important and necessary for us to look into how we could use these guidelines and the position of South Africa through the POPI Act, that we could see how we could take that into the continent as an African model of protecting children's interaction with the digital space. But until we do that, then we can guarantee that from a legal perspective, there's a level of redress. If we are unable to do that, then children stand in a position, or they are in a position that they're very, very vulnerable in that situation. Given that we as a Center for Human Rights, we have observer status with the Committee of Experts, for example, on the rights and welfare of the child, we will definitely grow on this collaboration with EndCode to see how we could take this conversation forward, put our efforts together, because we already have materials within with our own studies. And now we have a guideline that we can calibrate to look how we could also assist the committee in providing certain guidelines within the continent that will allow our children to interact safely. The law provides a very strong foundation for redress in cases of abuse, which doesn't exist yet across the continent. And the African Charter as well is also extremely silent on it. And you can understand that because the Charter was adopted 31 years ago, before the internet actually became this fashion issue, or this lifestyle aspect of our lives in the continent. But we can definitely move that forward by looking into the provision, Article 10 of the African Charter, that speaks to the right to privacy, and see how we can improve on the existing text to protect our children online. Some of the things that are very prominent in our continent, and this is Article 10 that I just flagged earlier, is that we are now at a point where there is no need to lament this inadequacy of the African Children's Charter, but to see how we can fortify it with some new text in a way of providing guidelines, which is what we are doing today, and also in a way that we can also look into the regulators or the regulations that exist in the countries that are flagged, and how we can take from that in order to generate legal protective measures in Africa, and that will speak to specific countries or speak to the region as we go forward. So we've come to a point where the digital environment is seen as a potential threat. So there's no way for us, there's no reverse here. We are moving forward because it has come to stay. And this morning I got a very, very interesting a WhatsApp message from a friend where even glasses are going to start having cameras on it. So we are in a position where we do have to appreciate, that's the first point, to appreciate the fact that we have internet with us and that it will be with us also as an enabler of rights for children, and that children will not stop interacting with internet. Education is also at a point where with the global pandemic, also as a point where it could move hybrid or completely online in some cases. So the internet is something that we need to take seriously. But for us to do that seriously, we have to balance that with the best interest of the child, which is what Priya also highlighted in her introductory remarks, the best interest of the child. And where I'm sitting is that for us to be able to protect and to implement the best interest of the child in a digital space, there is need for collaboration between the state, parents, and the child. And this is because children's interaction with internet in most cases is done in the private space, and that's in the family environment. The state can legislate, the state can put the laws in place, but those who are going to implement these laws and to ensure that they are indeed favorable to the child who interacts with the internet space are the parents. They come at the forefront of this, of the implementation of this in that private environment. As we all know, we learned recently that China has put a limitation on children's time, games, and all whatnot. That might not be a good approach to follow. That might not be a good example to take, but that as a continent, we do have regulations already. And as at the regional level, we might have to look into ways of generating laws and provisions that will work for parents and for the state to continuously collaborate with parents to protect these individuals online. But then what are some of the dangers that children face when they have this without being monitored online? And then I will skip this slide and then I'll come here to this particular one. There are some cool stuff that happen online now. Very cool. The first one is maybe facial identification. So we allow our children, most of our children have phones now that they use their faces to unlock those phones. But there's data that has been collected in that process. It is collected and it is stored. Because if it's not stored, then the phone will not remember that face. Those are cool stuffs. We allow them. They happen. So children have a risk as well of when they use their fingerprints on on their phones and their gadgets. We do know that with time, fingerprints have become this very important aspect of our identity cards, of contracts that we sign and all whatnot. So they might not be at risk at the moment, but in future, when they need those fingerprints, it might have been tampered with in many ways. So it's not like it is something that the child owns it at a particular time. So in this particular slide, I try to flag out the fact that there are two ways that the child can lose their privacy online. And the first one, it could be automatically, and you have also voluntarily. And bottom line, at the bottom, I try to break down what this could mean in many ways. Voluntarily, of course, we give our information. There's not parental control, so parents could also provide their own information, putting the child at risk, and automatically through accepting cookies that allow us to access the web pages. Not all cookies are bad, because some allow us to access certain educational pages, and some, of course, take us to different levels. But for me, the biggest danger online is parental ignorance. Parental ignorance, as I said from the beginning, is that most children are very, very, very educated in a way that some of us do not understand with how they interact with the internet space. And parents want to help, but they do not have the tools to help in that space. And because of that, children might find themselves in certain aspects interacting on the internet that are not beneficial to themselves and to their well-being. I resisted flagging obvious dangers that exist online, such as online sexual abuse or sexual exploitation. Those have been there for a long time, and there are some measures that have been taken in criminal courts in different countries across the continent to protect those measures. But some of these measures have not been taken care of yet. And parental ignorance is something that we need to look into. And those of us who are parents, that we try to up our game in order to protect our children and their interaction online. I'll also leave that slide, and then I move now to what I've looked at as turning bitter pills to sweet pills to protect child privacy. It might be good now, but given the fact that we are moving towards the fourth industrial revolution, this continent might need to move a bit faster to look at issues around physical address. There is a threat. If you read what our colleagues who are in the global north or in the south or in Europe, wherever write, they say that the fact that internet connectivity links up to physical addresses, it exposes the child's privacy as well. But we don't have that in this continent, do we? We don't have that in this continent, many parts of our continent, because we do not have proper physical addresses. It might be a good thing now, but it is not good in the sense of postal delivery. But it could be good in the sense of protecting the child online. So there's a need to look at that balancing and to see how we can also catch up with protecting children online when our addresses are sorted in the right time. We have poor internet connectivity in the rural areas, especially. So there, the dangers are a bit minimized. And then we have analog television, which is still ongoing as well in many parts of our continent. So in that space, the internet is a bit also minimized. Those who are futurists and will do futurist studies, they have different arguments on this aspect that I've highlighted here, because they want to see a world that moves forward into the fourth industrial revolution. But those who want to keep onto traditional aspect of these bitter pills that we have in the continent, that these are also aspects that can protect the child online. So all is not gloom here. We have certain things that protect us. We move on. So I would like to conclude now by just flagging the general comment. And the reason why I kept it very, very thin is because of time, and also to allow us to interact with questions. You can ask me all your questions, and I'm sure that through responding to some of your questions, I will be able to deal with certain aspects that I've not dealt with. Thank you.
Thank you so much, Dr. Porcala. I think that's an excellent presentation in terms of just bringing home the significance of what we are discussing today. And thank you as well for that, for placing just not only just the context of the human rights system and the children's rights as they are developing, but also just giving us more insights into the evolving capacities of children. That very, very important principle that we need to take into our work. I found myself listening to you not just as a lawyer, but also as a parent, and just really drawn into what the dangers are, the developing dangers are for children online, and just that imperative that we as a community, as a village, whether we are parents, teachers, regulators, experts in this field, that joint responsibility that we have to make sure that we see some progress in the safeguards that are available. So thank you for that. And I think now it would be time to introduce Alon Elkele from EndCode. We see each other constantly. He's such a great pleasure to work with, a brilliant mind. He's one of the senior advisors at EndCode and works extensively with our clients, whether it's on some of the risk and compliance work or some of these emerging areas. He's currently authoring also a book chapter on automated decision-making and profiling under European and South African data protection law. He's been driving this project. He's the lead on this project. So it's a great pleasure to welcome you now, Alon, to present the model guidelines.
Thanks very much, Priya, for the introduction, and to Dr. Porcala for a really, really interesting and pertinent, introduction to this emerging issue that's, been evolving for quite some time, that will continue to evolve as technology and, our regulatory environments move forward in our new worlds, and there's going to be many of them. So I'm going to be speaking to the model guidelines, and to begin, I'd like to just start with a quick overview. Priya did obviously introduce what we're doing and where we came from and how we approach this. But what I'd like to spend a minute or two on is just to speak to the audience on how to navigate the guidelines, and ultimately later in this webinar, I'll also speak about the utility of them. For now, there is a website that will be publicly available to everyone, and I'll share that later on in the webinar. And on there, you'll be able to download and access the guidelines. There'll be two documents, one where it will be a graphical representation using icons and a range of statements. And those together, those 9 statements together form the model guidelines. Now, what we'll see in this presentation I'm on now is that the 9 statements have been categorized within the 8 different processing conditions of South Africa's privacy law, the POPIA. Okay, and that will all come to make sense shortly. Then what we did was we also put forward a guidance document, and within that document, we reiterate the different model guideline statements, and we also provide answers to the following questions. What do we mean by the guideline? Why is it important? And how can you adhere to the guideline? And just on that topic, I'd like to re-emphasize that we have put forward various recommendations which are available in the guidance document. But it's really important to remember that technology and the way that regulators and governments and lawmakers approach controlling the issues that arise from the technology is really ever evolving. And what might be appropriate today or in 2021 may not be appropriate anymore in 2022 as things evolve. So just keep that in mind as I walk through them. Okay, but having said that, the model guidelines. The first one really has been emphasized quite consistently already in this webinar, and that is to consider the best interests of the child. And when we talk about considering the best interests of the child, we're asking online service providers, whenever they're designing and developing online services or products that can be accessed by a child, doesn't matter if they're designed particularly for a child, but if they can be accessed by a child, the best interests of the child should be a primary overarching consideration. In doing so, online service providers should take steps to understand their audience and the recipients of the service or product, and also implement appropriate processes to ensure that the best interests of the child are embedded throughout the online service or product. So this guideline really is broad and overarching. It falls under the accountability principle in the POPIA, and it would do the same in many other data protection laws and frameworks. And you will notice, as I speak to some of the recommendations for adherence, there's overlaps obviously between them, but when put together, we expect that online service providers would be in a much better position to protect children's privacy. As some of the methods of adhering to the guideline, we ask OSPs to consider knowing their audience and their age groups. As if you don't know this, then you can't begin to approach how to actually consider the best interests of the child and incorporate all the other recommendations that we've put forward. Now, in many cases, it will also be very important to assume children involvement. And if we look at, for example, an e-commerce provider online, even though it may not be directed at children, if they're selling children's books or if they're selling children's games, or if there's anything that children may be interested in, even if it's scientific journals, they need to assume children involvement, as Dr. Porcala and Priya put forward. Children's capacities are evolving and their maturity is also evolving. And it would be best practice to assume that a child will be engaging. In doing that, we ask OSPs to plan for these children users. And what we mean by that is to plan with the right tools and mechanisms, whether that is, as we will see, when you're obtaining consent from a competent person, their guardian or parent, or whether it's empowering them to access the information or change it or download it, or at least lodge a complaint with the provider. So to plan for the children is really important. And extremely important is to support the needs of the child to be represented. This is also obviously a global child's rights principle, and it's very deeply intertwined with the best interests of the child. And as the child evolves and as their maturity and capacity evolves, the need for representation will dwindle. But it's very important for the OSPs to understand who are they interacting with and dynamically provide them with what they need. The next guideline is adequate consent. When collecting and using personal information belonging to a child, OSPs must ensure that they have obtained complete and adequate consent to do so. And after obtaining consent, it must be as easy for a child or their guardian to withdraw it as it was to give it. And if we look at this figure in the middle here, this is what most of us will see when we're engaging with an online service provider online. There's a tick box and there's hyperlinked terms and conditions or privacy policies or a cookie notice. And what we're really pushing for here, I'm going to start with the second recommendation, is to rather provide children with unbundled consent options. We do not want OSPs asking children through their parents to provide consent to everything that the online service provider wants to do. We need to see each and every purpose separately. And as we'll see later in the presentation, some of them need to be drawn attention to even further, especially when an online service provider wants to use that information for other purposes in the future. Vitally, when we're looking at age gates, we actually want to recommend online service providers to prompt children for parental involvement. Now, of course, this would interplay with the first slide. What age and what maturity and capacity is the child at? But ultimately, especially in South African law, and it would replicate itself in some other African laws and globally, consent from a parent is a prerequisite. You cannot get consent from a child and it will not be valid in South Africa. So we want children to be prompted. We want them to go towards their parents and ask them for consent. Also, just-in-time notices and layered notices should be considered. So depending on the child's age and maturity, they may not be able to conceptualize a whole long privacy notice. And so we would recommend that OSPs look at giving information at the right moments in time when a child is interacting with specific features of a platform or website, and to layer the notices, so to break up the information, but as a whole, to get it across. Minimal processing footprint. Now, this is falling under the POPIA's processing limitation condition. Okay, and online service providers must only collect and process personal information of children insofar as it is required to provide the intended online service or product. And I've written here necessity. There's a necessity test that's been put forward in a lot of other jurisdictions. And what we're looking at here is really for online service providers to ask themselves the question, is the information of the child necessary for me to provide the product or service to them? And if it isn't, then we would opt to for online service providers to look at rather adopting zero data or minimality policies. We want OSPs to conduct necessity assessments. So at the beginning, to understand what do they really need and what don't they need. Of course, we are looking at privacy by design and by default. Okay, two different concepts, but both of them support minimal processing. We want our OSPs in their design stage to think about how can they, at that point in time, structure the service or product in a way that reduces the amount of information they need. And when children access it, to obviously customize its settings so that the less personal information is collected from them. Now, avoiding non-essential profiling of children is also recommended. And echoing what Dr. Porcala was mentioning, there are certain cookies, for example, which is a form of profiling or automated tracking that is essential. In some cases, you cannot use a service without it. So the necessity and the requirement, the underline they're required, that really should be coming into all of these considerations. Is it really required? And if it is not, then we should rather not. Lastly, vendor due diligence. Really what we're asking online service providers to consider is to embed not just minimality, but all of these conditions throughout their supply chain. So if they're using another service provider who's providing them a service as part of their product or service, a lot of words, then we ask them to please make sure that those service providers are complying with this guideline too. Be purposeful. Okay. Online service providers must be clear about the specific purposes for which they require personal information. And in doing so, they must be consistently guided by these purposes when designing, developing, and operating an online service or product. They must also limit these purposes when a child may access, use, receive, or engage with the service or product. Now, I've written here that there's a very strong internal focus for online service providers. This would come down to, from the way we see it, a lot of planning internally, through organizational policies that guide different teams, whether it's a development team or the marketing team, to guide them to understand what do they need, what do they not need, when should they be requesting such information and for what purposes, and when they should not. So really, it's a strong internal focus that needs to be adopted within different organizations. And we ask them to look at purpose-driven data collection. If there is no purpose for it, for when you're engaging with a child, then you simply should not be collecting their information. And the same goes for setting up high privacy default environments. When children interact, only the information that is necessary for the purpose of providing them the product or service should be obtained. Restraints in use of personal information for other purposes. Okay, so online service providers must exercise restraint, and they need to be transparent before using or sharing personal information of children for purposes that go beyond the original reason or purpose that they originally wanted to obtain the information. Okay, so it's obviously in when we're looking at online service providers today, data is the new oil. We've all heard that statement. And online service providers really need to be, they need to hold themselves back in using information of children for other purposes. They must also always assess the lawfulness, reasonableness, compatibility, and potential consequences for a child before using such information for other purposes. Now, when OSPs consider how to adhere to this guideline, we're asking them to consider dedicated consent mechanisms for further processing. Okay, the reason we say that is because in South African law, if you get consent to further process, then you can, and that's it. So we want a lot more transparency for children and their parents or guardians when they're signing up for a service or a product to specifically and separately provide that kind of consent. We also want compatibility assessments to become an organizational norm, just like a data protection impact assessment, for example. We want compatibility assessments for children when processing their information. And of course, providing adequate protections when sharing a child's information. And that comes in both technical and legal forms, whether it's pseudonymizing or encrypting their information when sharing it, or binding the recipients of their information to certain legal constraints. Ensuring high quality personal information, it's falling under our information quality condition. And here we're asking online service providers to take appropriate technical and organizational measures to ensure that all personal information of children that is collected or generated is accurate and up to date. And these measures must also make it easy for children at their varying ages and degrees of maturity to rectify the information that they've provided or that has been generated about them. And as you can see in the statement, we're talking about collection and generation. So with a lot of new technologies, including profiling, data is being generated all the time. And on that note, we want online service providers to avoid non-essential profiling. We don't want OSPs to be profiling children at these ages, and this should be done by default. We also want OSPs to consider avoiding nudging children to provide inaccurate information. So if you're age gating your service or product and you require them to enter at a certain age, they may very well be nudged to do that. And similarly, OSPs can consider to positively nudge children to provide the right type of information. And they can use the same types of nudging techniques that are often done for negative purposes can also be done for positive purposes. I'm not going to go over the prompts and just-in-time notices again, but yes, they can be used to also prompt children to and remind them to please provide accurate information. Now, transparency and accessibility, it links to the condition, the guideline on adequate consent. Okay, and what we're asking is that OSPs ensure that the ways in which they collect, use, and share personal information are transparent and easily understandable for children, once again, at their varying ages and degrees of maturity. When they're doing that, OSPs must ensure that such information is easy for the children to locate and navigate, and that they are provided with sufficient explanations and guidance to enable them to understand the consequences of using the online service or product, and also what rights they have. Now, in enabling them to understand the consequences, it's interlinked with them seeking representation from their parents or guardian or competent person. We want children to foresee that there are potential consequences and seek guidance from their caregiver. Importantly, today, a lot of online services and products are not designed to be accessed by children. I could even go on to argue that certain games, the privacy policies on those games that are children games may not even have child-friendly privacy policies. And for this purpose, it's integral that OSPs adopt child-friendly privacy policies. We encourage OSPs to look at the use of icons and visual signifiers, maybe even animations and comics to put forward other fair processing information. So that's integral, and it will really reinforce the extent to which children seek representation and the quality of the consent and the adequacy of it that is given by their competent person or guardian. So dedicated security safeguards. Here we're asking OSPs to implement appropriate technical and organizational measures to ensure the confidentiality, integrity, and availability of children's personal information. Now, these are standard technical requirements, but they also need to be applied to children's information, and in some cases, actually more so. In many jurisdictions, children's personal information will also be deemed special category personal information and will deserve extra protection. Now, importantly, where a child's personal information has been accessed, damaged, deleted, or destroyed by an unauthorized person, effective measures must be put in place to notify the child in a manner appropriate to their age and degree of maturity, and where possible, they're a competent person. So on that last point, and under the first recommendation listed, what we're referring to is a novel approach to have breach notifications that are child-friendly. Okay, if a child is the owner of the device or the profile, and they are the ones receiving, in their email or in whatever form it is, that breach notification, it's essential that they understand what is going on and what they need to do. We also want them to go again and seek representation from their parent so that they can secure their rights. Otherwise, we're also looking at OSPs avoiding high-risk software plugins or tools. There should be a standard of due diligence that's incorporated as a security safeguard when a child will access or use an online service or product. And OSPs need to be more stringent about really who they partner with, and they need to uphold higher standards, assuming that children may interact with these devices or services or products. The last guideline is that children must be enabled to participate in the management of their personal information. And here we are asking OSPs to design and implement tools and processes to enable children to access, alter, update, delete, or download their personal information, and to seek assistance from and lodge complaints with that online service provider. When they're doing this as an OSP, these tools and processes should also be appropriate to the varying ages and degree of maturity of the child. So we can see as a golden thread through all of these guidelines, it's the best interest of the child, and being cognizant of their varying ages and degrees of maturity is essential. And in doing so, OSPs would be in a far better position to comply with actually what the law is requiring. All of these guidelines are stemming from data protection obligations that are entrenched in our law. But what we're really trying to do here is to unpack them in a practical way and contextualize them based on, with influence and with reference to all of those international best practices that Priya referenced in the beginning. Under this guideline, we'd recommend that OSPs incorporate child-friendly privacy dashboards. So we want it to be easy for a child to log onto a service or open a game or an app or a product and navigate in an easy way to a dashboard where they can have options to access their information or to edit it or to download it. And likewise, once again, bringing in the importance of representation by their parent, we want to recommend OSPs to incorporate support portals for children or chatbots that are designed to engage with children at varying ages. And OSPs really can be creative in how they incorporate this. And with technology, I think that there's a lot of opportunity to use the technology to enhance and enable the participation of children. Now, as some concluding thoughts, I've already emphasized, that all of these guidelines are stemming from entrenched data protection obligations. And in many ways, the guidelines are reinforcing the accountability of online service providers. The accountability obligation is one of the most important overarching obligations, and it stems within all of their obligations in the law. So we really would want them to look at how can they do things better for children. We want to guide and influence the OSPs. There are many, that may not have the resource to, conduct an assessment of how they can apply the law to their organization. And we're hoping that through these guidelines, it would make that process easier. As I've also mentioned, I think it's imperative that when interpreting these guidelines, when using them, such use and interpretation must evolve with technology and best practice. If we look at a few years back, if these guidelines were brought out then, we would not see their application in the same way as we are today. Another aspect that I'd like to really just push forward is that globally, this topic is of paramount importance, and it's incredibly timeless. As Dr. Porcala was mentioning, that there is an opportunity here for Africa to take to get really a head start and get this going at a regional and continental level. Internationally, regulators, especially in the UK, they were the first actually to take such steps. And in the UK, their code is actually law. It's legally binding. And online service providers in the UK have no choice but to comply with it. The Irish Data Protection Officer and the French authority too have also put forward recommendations on best practices for OSPs. We're also seeing industry take this a lot more seriously. Facebook, Instagram, TikTok, and Google, all of whom, may in the past have neglected this area, are all also recognizing the importance of doing things better. So it's really timeless, and we do hope that South Africa and the rest of Africa, of course, will follow these global trends and, importantly, protect children within the digital world and not from it. Also, echoing what Dr. Porcala mentioned, it's already too late. We are here and we are not going back. Children are going to be born into the digital world, and we have no option as different stakeholders in society, including parents, to just at least move forward to protecting them within it and not from it. So I'm hoping that sheds some light. There is a lot more detail to be found in the guidance document, and please feel free to peruse it and ask as many questions as you require. Thank you.
Thank you so much, Alon. And I think I'm hoping that participants now can see the detail of the guidelines. We started out with this big picture of the principles, the fundamental principles that informed the approach to the guidelines. We then spoke a bit about the context, and we had that excellent presentation on the clear and present dangers to children online. We hear the message loud and clear that this is timeless, the time to act is now. There is something in this guideline for a range of stakeholders. And so we see its utility in so many different applications, but ultimately we're hoping that this also just catalyzes additional work in different countries that may be inspired by this effort to take something that may be abstract at a principle level and then to interpret regulations in this way to reach critical points where there's an opportunity for change. And the scenario that we have picked is just that room that we imagine with online service providers or product developers just designing the product or service that they foresee rolling out, and what would be the guidance, the essential guidance at that time that they could embed in the way that the technology is designed. So thank you so much for that, Alon, and thank you for some of the comments that we are receiving. I know that there are a few questions still in the chat and in the Q&A, and we'll get to them shortly. Now, the next presentation is by T. Manua, who is a Kenyan creative and a current law student at the University of Birmingham. And they are the creative behind Obsidian Circus, an art platform that's aimed at challenging social norms and overcoming restrictive social cultural boundaries through visual art pieces and creative writing. T's interests in the legal field include IP law and the intersection of human rights and tech. I remember very vividly, because this wasn't so long ago, the conversation we were having at the office about how we make this relatable and how we make this visually just something that appeals, so that we can have the attention of the various stakeholders that we would like to rope into this process, and hoping that this catalyzes efforts for them, whether you're lawyers or regulators, whether you represent children's interests in various forms. So it's a great pleasure to have been exposed to the incredible talent that T brings, and to have seen her interpretation of these model guidelines. I want to hand over now to T to walk us through her representation of the model guidelines. Tia, are you ready?
Already. Thank you. I would just like to say thank you to Priya for that lovely introduction, and also to Alon and Dr. Porcala for such wonderful insights on what problem areas are and just ways we can combat such prevalent problems within this area of tech. Like Priya introduced, my name is T, my pronouns are they, them, and I have done a visual art piece to visualize and put forth these model guidelines. So I will share my screen and kind of take you through my visual interpretation as the artist and what was going on in my head when I was designing these features. But firstly, I would like to kind of just speak on what excited me about this project. So when I first spoke to Priya and Alon, I was just absolutely buzzing by the project. First of all, it involved me doing art, which was the first point of interest, because I'm a creative. I love it so much. Anything to kind of help me paint, do any digital work, anything. And I'm currently very, very interested in tech law, and have been taking on a couple projects involving digital ID, digital authoritarianism, and AI and personhood, and kind of those areas and their intersections together. So putting this piece together and working and understanding these model guidelines and getting to know more about EndCode really excited me and kind of like piqued my interest, because it fits into areas that I'm interested in already. And as like a young budding law student, it's so eye-opening and something so important that I think was great for me to see, for me to engage with, and etc. But without saying too much, I will actually get to the art, probably much anticipated, and we'll share my screen to go through that. 1 second while I do that. So hopefully everyone can see that. But that is the final piece that was produced. Feel free to ask questions and drop questions in the chat box, drop questions in the Q&A section if you have anything you want to ask about, I guess, any of the interpretations or anything. But overall, this is the piece. And as it is model guidelines on age-appropriate design and really focused on children, I wanted to make it look very much comic book themed, which is what I was going for here. I made it vibrant, I made it neon, but also with this kind of like underlying depth and this looming darkness to it. So instead of using vibrant colors like, reds, pinks, oranges, yellows, I used cooler tones like blues and greens. I also just really like working with blue and green. So that was a fantastic opportunity for me to use colors I like working with. So in this piece, each character is representative of a guideline point. And I left it very, very open for interpretation. So at first glance, it might look like this has absolutely nothing to do with the model guidelines, or you may note small pieces or nuances in the page as a whole that pertain to certain guideline points, just based off the icons that Alon showed us in the guidance document. But yes, I will go through each individual character, how it pertains to the guideline that it's fitting to, and the inspiration behind that character. So the first character is this one down here. I will zoom in, but it's this one on the left. This is the consider best interests of the child. So I kind of made it a very plain figure. There's not much going on emotionally. It's not a very emotive character. It's kind of just plainly there. And so with the best interest of a child, I wanted to make it very dull, right? Because this is kind of showing what would happen if we did not pay attention to the best interest of the child. And if we did not focus on the primary subject of why this whole process is being worked on and being modified and being made available. So it's kind of just a plain looking figure like, yep, I'm bored. And this is me just being left to the side, being pushed away, being unattended to as someone who's not being addressed in this process, right? So if we kind of did this whole process without considering the best interest of the child would be, again, a separate takeaway, would again be a separate figure kind of pushed aside. Like, I know what's best for the child. The adults would say, for example, I know what's best for the child, and the child doesn't know best for what they want, for how they want to proceed with online services. And that's kind of what I wanted that to encompass, very plain, very just straightforward looking character. Now the second guidelines I kind of paired into one because it was 2A and 2B on the document. So the first one being adequate consent, and this is this figure in the middle. So I kind of juxtaposed imagery here and put a very subtle small I consent tick box at the bottom. I hope you can see my cursor, but I consent tick box here. And I made it very small and unnoticeable because it's kind of hitting the idea and opposing the fact that we need consent. We need clear and direct consent given by a child, by the guardian, by the people using this online service. And a lot of online service providers do not make that clear enough, do not make it so that we are getting clear and vibrant and enthusiastic consent. And so having that, a very small image, a very unnoticeable detail of the piece really spoke to me in that sense. Likewise, also with the processing footprint, the minimal processing footprint, I made it kind of a really big in the middle literal footprint under this person's shoe. Because again, juxtaposing minimal, maximum processing. So this image is just really big because it's like we're trying to focus on getting minimal or like using a minimal processing footprint, processing only the information that is needed. But a lot of the time, more information than is needed is processed, which is why the foot is so big. It's kind of challenging that idea. And that is what's happening with the second character. Now, moving on to the third guideline is be purposeful. If I keep looking this way, I'm reading the guidelines to kind of to explain this, but the third is be purposeful, and that is with this three-headed figure on the left again. So purpose to me, when I think about purpose, when I first looked at that guideline, I thought very much all over the place, misdirected, like there's no clear, focused sense of direction. And this is what I wanted to show with the three-headed figure, because if the figure was just one-headed looking forward, it would be purposeful. It would be, this is my direction, this is the way looking forward, I'm focused. But this doesn't have, it's kind of purposeless, it's scattered, it doesn't know what it's doing. And that is kind of like a very plain, simple visual interpretation of the term purposeful, or to be purposeful. And the guideline states that we have to have clarity about the purposes of which the online services providers are using such data, and they can't really deviate on the purposes to which they're using these data and switch purposes or drive, and should persist with their original kind of determined purpose. Like, this is what this online service is going to be used for, and this is how we're going to do it. And yeah, that figure incorporates that, because it's very scattered, very much, this is what happens if one has no direction, if one is lacking purpose, just kind of looking everywhere, not really zoomed in. The next one is restraint and use of information for other purposes. So that is this, that is this figure down here. And it's not very obvious at first glance, but they are in a straitjacket. And for me, restraint basically kind of went hand in hand with the imagery of someone being wrapped in a straitjacket. And also I wanted to make the face have both a very plain looking expression and also an expression that's very much double-ended, double meaning. So like, this person's in a straitjacket, but the expression is looking forward, and you feel in some sense that they're kind of plotting in their mind. Also makes you wonder why they're in a straitjacket, for what reasons, what did they do, what happens here, because we associate straitjacket with someone who needs to be controlled, someone who needs to be confined to their space so they don't damage anyone else. And so I see this to be the online service providers who abide by that restraint and the fact that they need to establish restraint in how they use information. And they shouldn't be allowed to deviate from the way they use this information. So this is a major problem. I'm aware that, I guess there's service providers will be like, I'm going to collect this information and maybe use it for this, maybe use it for this. I'm going to say that I'm going to use it for this defined purpose, but behind the scenes, I'm thinking of further down the line, once the user has forgotten they've given me this information, or once the user continues to use the services, I shall take their data, input it in little small sections, and this is kind of my behind the scenes plotting on what I can do with their information after they've forgotten, or after it's less fresh in the mind of the user that, hey, I've given you this amount of data, I've given you this data. Yes, I hope that explanation is clear. The fifth point, ensure high quality personal information. That is this figure up here with the futuristic looking glasses. I made it more futuristic looking because those space alien-y futuristic glasses, that imagery gives me high quality in the sense that if you look at, let's say, a comic book character or a movie or some sort of cartoon like Teen Titans, which was a big mental inspiration for this, you'd imagine that if a character was wearing such eyewear, it would give them clearer vision or different vision, actually, like supernatural vision. And yeah, to me, that was kind of clear cut that the glasses represent a higher quality in visuals, higher quality in vision, and just higher quality in general. And there's also some duality to this character because glasses are also linked to perception and how we view the world, from what lens we view the world. And it kind of plays into the idea of the digital ID and digital authoritarianism, because if you fail to ensure high quality information and data is collected, then this could completely skew how the data subject is perceived. So if you fail to collect the correct data, if you fail to collect it at such a high quality, we could misperceive and misinterpret the data subject and thus cause problems with, I guess, the digital ID. And this is prevalent in situations where you have identity providers. So for example, Google. We all know the Google and Facebook, sign in with Google, sign in with Facebook, sign in with this. So that was kind of the inspiration behind that one. And for the sixth guideline, transparent and accessible privacy practices for children, I did this character with the open pink, vibrant pink and neon pink brain with a projection of the "you want this" in text here. Looks kind of like a TV screen, like one of the old TVs with a lot of noise and the little dots that you see. So this is symbolic of online service providers using psychological manipulation to nudge children in a certain direction and nudge them to make certain decisions online. So Alon talked to us about nudging, so I won't go too much into that. But there's a lack of transparency and clarity as to why children are making certain decisions online with the information they give, because I find online service providers don't really give us or give children that clarity. So this is very much prominent with the "you want this" being projected from the person's hand, because I feel when I designed this, I felt online service providers kind of use flashy buttons or certain phrases, certain language in their technique saying, you know, "you want this." So I'll use the example of gaming. On gaming platforms, they have a thing that's out there like, you want to give us this information, you want to consent to this because you want to play a game, you want to get the coins that level you up in this game in particular. And the seventh one is pretty simple. It's up here with the little lock, same as on the guideline, there's a little lock over there. So it's basically a person very loosely holding this lock. So it's, yes, we have dedicated security safeguards, but very loosely, like we're not really making sure they're clear and making sure they are working. It's kind of very loosely and nonchalantly holding it like, oh yeah, I'm just gonna have security safeguards for you. I'll throw them in there as a plus to make you think we're being secure with your information. And lastly, this figure down here, very gray, very dark, with the empowered kind of cross tape across the mouth. The children must be enabled to participate in the management of their personal information. And the idea behind this particular figure is kind of empowerment, but in a very distraught and upset kind of way. So the issue of this being that a lot of children are led to believe that they are empowered in the information that they put online, empowered in controlling their own information. And while this is true in principle, we can find it in laws, for example, legislation, policies. It's not necessarily very true in practice. And there are multiple cases where there are multiple situations where this is the case. And so that's just emphasizing that, yes, we've been told we are empowered and we have control over our information, but do we really have that control? Do we really have that empowerment? So empowerment in this sense is kind of illusory, sorry. Yeah, and that is the end of my interpretation of each character. You can leave any questions in the chat if you want, and I can go in more depth about the characters. I haven't had time to read the chat. I've seen it's been popping a little bit. Yeah, that is the end. And if Priya will permit, can I quickly go through my website?
Perfect, please do.
So Obsidian Circus, like Priya mentioned before, and it was in the agenda for today, is my website. And I don't know, the screen is paused. I think I need to reshare. This is Obsidian Circus, my website, my platform, where I produce art to combat social norms, to look at issues such as race issues, LGBTQ activism, and just a bunch of issues alike. And my art is very versatile. There's digital, there's very abstract, acrylic, kind of like this image here on the front page. And yeah, I basically fit whatever art I do to the theme. So for example, this one was the theme of kind of children. So I made it very comic book-like, very, something a child would pick up in a shop and be like, this is cool, can I buy this? For example, to whoever's with them. And so on this website, I have explored different collections. So for example, my favorite one is the Society collection, which is just clicked on, where I talked about, or I kind of narrated a story throughout the different pieces of why society, there's so many problems within society at the moment and what these problems are, and kind of took the viewers, the audience through these problems, through these very abstract and bold pieces. I also have another collection, the Alphabet collection, where this is all digital pieces, and I took people through, it's called the Alphabet because each piece is titled with the first letter of each piece is titled as the alphabet goes. I've only gotten halfway through the alphabet, but that's how it is so far. So very vibrant. I took this idea and this collection and put it into the model guideline interpretation. So you can see very many similarities here with that. But yeah, I'm kind of working on many other collections behind the scenes, and this wonderful commission that was an amazing opportunity to do, which you can find here, an attribution to EndCode and the model guidelines and the landing page. And this is kind of just my open to, if you liked the art, feel free to contact me for more interpretation. I don't know what just happened. For more interpretations of the art, if you would like. There is a contact page on my website. You can just send through a message. Let me know if you would like to collaborate on anything, if you would just like to ask a couple of questions on what's going on with some of my pieces, or you'd like to read some of the work, some of the written work I do, poetry and creative writing, which is in the Sidian's Black Book area. So
thanks so much, Tanya. Thank you so much, Tanya. And yeah, I think you'll definitely hear from us again. We're delighted to have met you. And I think, as the comments suggest in the chat, and the various comments and our own experience just in working with you, this has been just a fantastic opportunity to have a multimedia approach to this project, and also just a multidisciplinary approach to the project. As you said, appealing to children, and I think so much more can be done in this area, so that we as policy experts, as legal experts, don't just speak in the language that we understand, but find ways, creative ways, to make our advocacy appeal to the people that we need to appeal to. So thank you so much, T, for that, and looking forward to working with you again. I think just a quick session now, Alon's I see his screen is up. He's just going to point us to the dedicated site that we have up just for the model guidelines. And what we are looking for is really your feedback and your endorsement, if you agree with what you see. And I see some comments even coming through just on the direct chat with me for more information and how to participate and so on. There's so much in this that can be taken forward in various ways by various people. So Alon, if you don't mind, maybe you could just scroll to the bottom of the page. And you'll see a short write-up. You'll see some of the guidelines represented. We've got the fantastic art by T on there. The research report that we mentioned is also available, further guidance on how to use the model guidelines, and then a feedback session. And of course, there is the endorsement page. So if we click on that link, you're going to find just a very short form. It will take you less than 2 minutes if you do subscribe to what's in the guidelines. We'd love to know which stakeholder you represent, your organization, and your endorsement of the model guidelines. If you'll bear with us, we will also reach out to specific people that have joined the session today, and others that we would like to see take this model guideline forward. Then I think, you know, there's another element of innovation within this project, which is a very specific analytical framework that was developed to be able to translate this big picture principles and regulations from privacy perspective into these guidelines. And for anyone doing work in this area, translating those big picture elements into something that is very specific. We're also very happy to share with you the methodology that was developed and the analytical approach that was developed through this process. So thank you to the various speakers, and I saw that some of the questions were responded to in chat. I wanted to reach out to the speakers just one last time and then ask them to revisit just some of the comments that came through, some of the questions that came through. Let's start with Dr. Porcala. There was a question in the chat, Dr. Porcala, about the bringing in the tech giants into this conversation. It's very well for us to speak about human rights and the rights of children and the imperatives and the dangers and so on. I wanted you to maybe just revisit your response to that question. How do we bring in, we're speaking to a diverse audience, and when we say online service providers, it can really be the smallest startup at the design stage, but all the way up to the biggest firms in the world. How do we bring them into this conversation? What is that bridge that we make from the human rights discourse to these tech giants? Dr. Porcala.
Thank you, Priya. And of course, those of us who spend time here now to follow some of the presentations that you've had, they've been amazing. And I think the guidelines have touched a lot of so many things that we can draw lessons from and to implement across the continent, with South Africa being the benchmark for that. But to answer that question, which I saw, of course, in the chat, and I thought was very important that that came out. What is important for us to know is that in a child's life, there are two main platforms, there are two main settings that govern a child's proper development. And that is the public setting and the private setting. In the public setting, you have the state and the organs of the state, or the agencies of the state that plays out in that environment. There you have the hospitals, police, the courts, and all whatnot, and of course the legislation as well. The state is the one that signs these treaties with the international bodies. So the state has a mandate at that level, or a duty rather, to implement the international conventions or covenants or instruments that they ratify. So in that public space, you have the state that sits as a guardian of regulations, if you might use that particular terminology or phrasing, where the state is the one that works through its legislative arm to adopt laws. So to bring the IPS or the Google or into the family environment, they are already in the family environment. But to regulate what happens in that level, it is a duty of the state in their regulations that they adopt at the national level to allow these parastatals to operate within a particular state. So when these parastatals agree to those terms and conditions that play out in those regulations, they need to also agree to protect children's privacy and to ensure that they put safeguards in place that will continuously protect children. So one thing that's also important to flag here is that even though these parastatals do play out in the states, that the interaction between children's rights and business, because that's a business corporate, we can't take that away from what they are out to achieve. They are a business entity, and their main objective is profit. It's profit margin, it's business. But the states, knowing that they have an obligation under international law to protect children, they also have to insist that in their operations, that is IPSs, that in their operations within a particular state and in providing the services that they provide to the consumers, in this case children, that they do take into place the rights of those individuals to ensure that they do not violate their rights by providing them these services, which in a way also promotes their rights. The internet is here to stay. It will not leave us in any rush. And our children, as I said before, they seem to come through or to be born with a particular chip of understanding how these things work more than us. So it's important that we have that cooperation, but to have the IPS in the family will be very difficult. Will be very difficult, but easy as well from a regulatory perspective. But I always insist that in the family environment, parents must up their game. Parents must, at every point in time, ensure that they already they also play their role. The IPSs already play theirs with parental control stop gates or gateways. Some of the parents just go on it and just put a particular age, and then they're allowed to have access into it because they want to allow a child to be quiet and to be distracted so that they can go on with their activities. We need to always bring in the best interest of the child in those particular environments and to ensure that it's not about keeping the child quiet that fulfills that particular principle, but that it's about ensuring that what the child is watching in order to be quiet is also suitable for the child. Thank you.
Thank you so much, Dr. Porcala. I think you painted that picture very well of just, who those key actors are in terms of holding organizations responsible. We are looking at it from a principal perspective, but ultimately we have to put into perspective what the role of the regulator and state actors and regulations are and the governance that we need. Alon, some final thoughts from you, and also just, responding to what we've seen on the comments here about the way forward, where to from here. Some comments coming forward about we need more accessible content for parents. We need to be able to translate this even further. So much more to be done. But where do you see, just in your closing thoughts, Alon, the utility for this? Anything that you can add in terms of where these guidelines can go, and who can build on this and what the opportunities may be?
Thanks, Priya. Yes, so I think as a starting point, it would be good to identify, who are the key stakeholders that would have most utility from the guidelines. And obviously we've spoken about online service providers today already. But if we look at, for example, civil society as one, I think they're a key stakeholder group that would reap a lot of benefit from the guidelines. One, as a form of training and awareness, but two, also as an educational framework in some ways to educate both parents and children on what their rights are and what they should be looking for in a safe environment online and what are non-safe environments. And of course, also regulators. That is another key stakeholder group where I think if we're looking overseas at the steps taken by other regulators, there is a prime opportunity for South African and African regulators to consider the guidelines, consider the references we've contextualized from the rest of Africa and overseas, and look at what mechanisms they have, whether it's through their own codes of conduct or whether it's through informal, non-binding recommendations for industry. It would be up to them, but there are definitely mechanisms, especially in South Africa. The regulator is empowered to create codes of conduct, and processing of children's information would be a category of processing that they are empowered to regulate. So it would be awesome to see regulators taking the opportunity, using the mechanisms at their disposal, and hopefully consulting the guidelines to take them a few steps forward.
Thanks so much, Alon. And I see T has posted a message, just let us know that the artwork is also available under a Creative Commons license. I think just a huge degree of interest in the various outputs from the research and so on. I think that's what we can take from this. So as far as we've come, there's just so much more that can be done for the different stakeholders. We happily welcome feedback, contributions, collaboration, and we'd love to see how you've used this, how you've taken some of the work that has come out of this project and used them in various ways. I want to extend a huge thanks to the Center for Human Rights for partnering with us on this project, Dr. Elvis Porcala for making time and for putting the presentation together, and for guiding us through this conversation just on the significance of what we are doing here. Why this is important and what is the kind of imprint that we can leave for our children. So thank you, everyone, and thank you, everyone, for joining us this morning, this afternoon. We will be in contact with more information on endorsement if we feel that you would like to endorse these guidelines, and just with some contact information and, of course, a link to the various outputs from this project. Thank you very much, everyone. Thank you, and bye-bye.